Hello and welcome to Tuesday Tips with Professor Bendistis. I am Professor Bendistis, and I'm going to come at you every Tuesday with either a video or an email to give you a hand with the multiple choice MBE questions that you're seeing both in your Jet Bar D emails and that you'll eventually see on the bar exam in the future. Now, the goal with these videos isn't so much to get into like the substantive law of contracts or torts, but more to talk about really specific ways the questions are phrased and approaches that you can take that can kind of make sure that if you do know the law, that you'll definitely get the question right. Now, I want to talk a little bit about myself, if I can introduce myself, if you will, really quickly. Just talk a little bit about what my role is here at Delaware Law School and kind of why we're putting these videos out. So I'm the Associate Director of Bar Passage here. I work with Michael Loss. We are offices in the Office of Student Affairs, which I bring up because like our job is to make sure that you can pass the bar. That's what we have classes for. That's what we spend our office hours on. So if you have any questions, either now or in the future, please reach out to one or both of us. My email is here. I'm trying to make sure I can, record myself and make sure it makes sense. But I'm happy to answer any questions that you have. If you put my name into YouTube, there's lots of video lectures on bar exam structure, MEEs, MPTs, other acronyms, just the same. And the idea being that like these questions are aimed at making sure that you're prepared for the bar exam in a way that I think is substantive, I think the way that's important, and in making sure that, again, you can use the best of the knowledge to pass in the way that I think you should, that your work pays off is the key thing that we're going over. Now, before I go over last week's questions to give you the tips that I want to go over, I want to talk a little bit about the MBE in general and why it matters and why it's important. When you ultimately end up sitting for the multi-state bar exam. Now, obviously, the bar exam is going to change to a next-gen model eventually, but for right now, especially people who are taking the bar exam coming up, the MBE is 200 total multiple choice questions. It's 100 in the morning and 100 in the afternoon. So if looking over these emails feels exhausting, I just want to note that eventually you're going to get ready to take that many questions in that period of time. There are 25 questions from the following topics: Civ Pro, Con Law, Contracts, Criminal Law and Procedure, Evidence, Real Property, and Torts. Now, as we're going to go over the next like 2 months or however long we're working together, there's different things to note for different types of questions, but a lot of very common themes are approachable in all types of questions. So a lot of the things might seem harder in property law than they might be for torts, but the idea of how you approach questions are usually pretty consistent. The last thing I'll note is that the passing score that you'll see here for Delaware, Pennsylvania, New Jersey, and Maryland are there. I think the big observation, the big takeaway I want you to have for this is that you don't need a perfect score on the MBE to pass the bar. You should always seek for perfection, right? You should be shooting for as many right as you possibly can. However, you can afford to get a few problems wrong. And so one of the things that I'm going to talk about today is the idea of taking stock of questions that you get incorrect. Where do you put your attention on when you're having trouble in, let's say, like property questions or maybe evidence questions, and sort of how to approach that issue to best effectuate your problem. Now, one thing I always like to talk about when thinking about bar exam preparation is you want to raise your ceiling, but you also want to raise your floor, meaning that for things that you're really good at, you want to get the best possible points imaginable. But for things that maybe you're not so good at, you want to make sure that you're getting enough points to give you the score that you want to make sure that you have to pass the bar. Now, the last thing that I want to share with everyone is that I am barred in Pennsylvania, Delaware, and New Jersey. I took all 3 bar exams. I passed on my first time. And for those of you who don't know me, who haven't heard this spiel before, I did go to Delaware Law School. So the one thing I always like to point out is that I had the same education that you did. I had many of the same teachers that you did, and I was able to pass all those bar exams on the first shot. So the key thing that we're going to talk about is we want to prepare you for things. We want to make sure that you're ready to answer those questions. But most importantly, if you have any questions in the future, you take the time to ask because we're more than happy to help. Okay, let's get to tip number 1. Now, what I'm going to do is also talk about the bar exam questions from last week. I want to talk a little bit about how to approach them and why some of those approaches might matter the further along you get down the road. So tip number 1 is know the law so you know how to improve. Right? It's a 2-part question, right? One of them is focused just on Jet Bar D, just these emails that you're getting in your mailbox, how to think about them, how to put them together. The other one is a little bit more important. It talks a little bit how to think about how these questions work later down the line and how to fix and improve upon issues in the future, right? First thing I want to note, I think it's okay to refresh your memory on standards of law that are key for the question. Now, here's what I mean by that. If we can jump to last week's question on contracts specifically, right? If we look at this question, you see the closings on August 1st. You got an email on July 15th. You got July 25th is the lawsuit. I'm guessing that most of you who have had contracts, and I believe that's everybody in the building, was able to look at that question and say, well, that's an anticipatory breach question, right? That's a question on the idea that there are certain times where you're allowed to file a lawsuit before the actual breach to sort of account for the fact that breach is coming, right? To protect your interests. Now, the question there when you see these questions is ultimately one of like, well, what best situates the answer? Now, if you are like me, right? And you saw this question and you thought to yourself, well, I know it's an anticipatory breach question, but I don't remember the standard. I think that's pretty reasonable. I've been a lawyer for about 20 years, and one of the things that I like to share with people that's somewhat unrealistic about the bar exam is it's one of the only times where you have to very deliberately memorize standards of law, and that memorization is very important. No one has ever called me into a boardroom and been like, we need to know what fee simple subject to condition subsequent is. Like, I can look at my notes, I can do the research, and I can figure out what those answers are in time. So it's not as though you're an emergency room lawyer. You always have the time to do the research and to make sure that you get your answer correct. When you sit for the bar, that's sadly different, right? You do have to memorize it. It's an unrealistic approach to the law that lets you be able to spot certain issues. My point for this exercise, right? You're going to get an email Monday, you're going to get an email on Wednesday, right? My point there is that if you see that it's anticipatory breach and you say, you know what, I don't really remember what the standard is, well, take a second and research it so that you can answer the question more appropriately. Because here's the main reason and why I think that's important. If you look at the standard for anticipatory breach, it's an absolute and unequivocal refusal to perform a distinct or positive statement of an inability to do so, right? Absolute or unequivocal refusal to perform a contract, right? Why that matters is when we look back at this question, we look at these answers, well, it no longer becomes whether we can memorize anticipatory repudiation well before we take the bar, but it becomes a matter of what does that mean? What does that standard mean in application? Why does that really matter? Now, I want to point something out real quick. Noting the idea that whether I don't intend to close on the purchase unless I'm legally obligated to do so, finger quotes, right? Whether that's absolute or unequivocal is a really important thing to note about the bar exam. If I had a nickel for every time I had someone tell me, well, I'm doing MBE questions, and whenever I get something wrong, I read the standard again. I think that's okay. It's okay. And I also think it's important when people say, well, I rewrite it again. Again, that's okay. But the thing that I think is important to note is that this question you might get wrong knowing the standard because you're not 100% on what it means to have an absolute or unequivocal refusal. That to me is the key. So my thing would be that if you went here and you thought, I thought that was unequivocal, I thought that was absolute, and if you're incorrect, what that shows you is that your understanding, your analysis of the element is incorrect, even if your memorization of the term is completely spot on. That matters. That's important, right? I also want to note that it's important because there are other questions that you're going to see are like this in the future. I recognize that my big head is canceling off some of these answers, but I'm going to show you a question that's an actual MBE question about criminal law. I'll describe it generally because I'm going to have a bigger point to prove. It's a criminal law question. It's a murder question. You're going to get a lot of murder questions when it comes time to take the criminal law MBE section. And essentially what it is you got someone who's doing target practice in what they believe to be a secluded area. It turns out there's a playground in the area where he is like shooting a gun and he ends up shooting somebody, right? Like again, I don't even know. It's that missed the shot and killed one of the children playing in the playground, right? Hypothetical MBE, obviously terrible, right? What this comes down to, though, is what was this person's mindset at the time that the action took place, right? If you've taken criminal law before, you know that there are multiple different mindsets when it delineates what type of murder you have. You have depraved heart murder, right, which is first degree murder. You have a reckless standard, and you have a negligent standard. Now, last year, when I asked this question at Bar Boot Camp, I had some people that was a distinguish whether is this reckless or is this depraved heart. Now, there are a few very sympathetic to murderers people who think this is negligent. I don't believe it is, right? But the idea is that you can memorize the word depraved heart murder. And you can memorize the word reckless until you're blue in the face. But if you keep getting these questions wrong because you're not applying them correctly, well, then the memorization of that question doesn't really matter, right? Now, how do you solve that problem from a bigger point? Okay. Well, one thing I'll note is that if you're looking for the answer or you're looking for like the standard, you can look in your notes right? Hypothetically, you can Google it if like you don't have the notes or you haven't taken that class yet. But another thing that you can also do is use a little bit of time to practice your legal research skills. Where what I did is I put the word standard \s in parentheses anticipatory breach into Lexis in Pennsylvania to get that standard. Right. So I like to use this search of the word standard for anticipatory breach because I want the sentence. The standard for anticipatory breach is. I'll also do things like element, same sentence, negligence. The elements of negligence are. The elements of, unlawful influence are. Trying to cherry pick the sentence so I can just get the definition that I'm really looking for. Now, the other thing is that if I'm getting anticipatory breach questions wrong all the time, it might not be the worst idea to pull a couple cases and just read them and get the practicality of how they work. That has always been really, really successful for me as a lawyer. I actually did that when I was studying for the Delaware bar to note a few things to kind of note what answers I was getting wrong and how to sort of account for them in the future. I have one last point that I also want to note for people who are third 3Ls getting ready to take the bar exam. Of a good idea that I did when it came to MBE questions in general, especially when I was taking big sample tests, 200 questions, 100 questions, is that I would make a grid, right, of all 6 topics. And then I would make a counter grid at the bottom that would account for questions that I got wrong. I would have questions where I didn't know the law, questions where I knew the law but didn't understand the question, and then questions where I was just super lost and where where I was like, I made a mistake, right? I read something incorrectly and I wish I could go back and fix it. So it was ultimately, I don't know the law, I don't understand the question, I've just made a mistake. And I would just account and put check marks for all 200 and look to see where the patterns were that I was getting into. If you look and you're like, well, I'm getting complicated property questions wrong. It's like, you can join the club, man, because like that's everybody. But I found that I was like, well, I'm getting easy evidence questions wrong, right? And I'm getting civil procedure memorization questions wrong. Well, like those are fixable problems, right? In the first one, I got to pay better attention, right? In the second one, I got to study my handout a little bit more. And so the point that I would just note is that yes, memorization is obviously key. It really dictates, again, how well you're going to do at a very big level. But if you find that memorization isn't the issue and it's the application, these are just a few points that I want to note that I think can improve your score. And I think starting early is a great way to think about it. Okay, let's talk about tip 2, right? Approach the problem practically and carefully, right? Let's talk about taking a look at some of these questions from 2 different perspectives that takes an idea of a big approach, but then one that sort of obviously is time sensitive, but making sure that you're really, really carefully looking at different words, different language, and making sure you're including the most important thing the questions is testing for. The first thing I'm going to know about practical application for the problem is to look at the elements of law before you look at the answers, right? Let me go down here really quickly. I want to talk about the torts question from last week. You have a teenager totally blind in one eye, 10% vision in the other, can't get a driver's license, goes and drives, getting into an accident, hits a jogger. It's a disaster. Hypothetical person disaster, right? The call of the question here, though, is really, really important. And it's the kind of thing where I want to kind of, again, we have plenty of time here. No one's taking the bar exam tomorrow, right? As far as if you're listening to this today, right? The point here is that if the jogger brings a negligent suit against the teenager and the jury finds in the jogger's favor, what is the most likely reason? You're going to get procedural questions like this. Why did this person win? If this motion is denied, why would that be the case? If this person wins a verdict, why is the likely reason? And I find that thinking of this question procedurally is the best way to think about narrowing the best answer. And so if I look at negligence, right, I'm assuming everybody knows the 4 elements of negligence at this point. You've got them sort of tattooed on your wrist, right? It's breach, duty, causation, and damages. And so if the jury finds in favor of this person, there would have to be a duty that this teenager owed, right? That this teenager breached that duty, that the breach of that duty caused damages, and the person caused damages. All right, cool, right? I'm going to look at the hypothetical here, right? And I'm going to sort of surmise that we're probably looking at a duty and a breach of duty question because of the particularities of that we got a teenager who's mostly blind. This is sort of the point where I'm thinking about the questions carefully of the idea like that stuff's there for a reason, right? The fact that it's a teenager and the fact that it's blind and the fact that it's on his 18th birthday just feels like it matters in a way where like that it doesn't need to be there if it wasn't relevant for the question. And as we go through the answers, you'll see that one of them very particularly calls on those points. So I just want to point out first of the idea of looking at something carefully and saying, why are these facts here? It's very rare that MBE questions specifically have red herrings in them that are there to confuse you. There's something that has to be particular. And so when I look at this point and we look at the duty that's owed and how it's breached the duty, you have to consider the fact that it's likely incorporating the idea of his vision and his age in certain respects, right? So when we look at this question here, we're going to go through some of these. I'm going to talk about this with further questions later on, the idea of really isolating the best answers, the worst answers, and things like that. But if we go backwards for a second, right, and we talk about why would the jury find this person to be guilty or liable, whatever. All right. So the first one, the teenager failed to exercise ordinary and reasonable care under the circumstances. That seems pretty good to me, right? Because the idea there is it accounts for the circumstances. I know that duty under a negligent standard does do that. Two, the teenager failed to exercise the amount of care that an 18-year-old with like education, intelligence, and experience would have exercised. There's a point there about teenagers and 18-year-olds noting the idea with like education, intelligence, and experience. That doesn't exactly account for the I problem, right? So, like, it's kind of there, but it doesn't quite account for the things that are ultimately necessary. And the idea that if I'm thinking really carefully about the jury's application of the problem, I think A is just better than B. And in that instance, I'm going to put that at a higher priority. Now, when it comes to C and D, I think that these are things that you can sort of think about in a way and convince yourself that they are correct. But ultimately, when we think about the jogger using reasonable care when struck by the teenager, if a jury's finding someone negligence, sure, they could consider that, but that's sort of reading a lot into the problem that just sort of really isn't there. We're not talking about contributory negligence. If that was the case, it would come up. The other thing, the teenager violated the law when he drove without a license. Yeah, that's also true. But the point that I would also note when it comes specifically to duty and breach is that's not a better statement of what that standard would be than A. A to me is just sort of a better standard because it better reflects those individual elements that need to be proven. Now, could D be negligence per se? Plausibly, but is that a better answer than A? Do you need negligence per se? I don't really think that you do, right? So the point that we're sort of getting into here is thinking about it from a matter of what is the question kind of looking to answer? How do we take a look at it again, practically? Grabbing the elements and applying them in a very specific sense, and then carefully noting little variables and nuances that are probably a part of the question because they're probably also going to be a part of the answer. Now, with that in mind, you have two questions this week that deal with constitutional law and criminal procedure. In both instances, if you've had those classes before, take a few moments to note what the underlying source of the law is, getting into it to make sure that, again, you've reflected your recollection when it comes to the issue at hand, right? Think about the application of the question, think about what's actually being answered. Those are the key things that you're going to be using. So the key things that are going to be helping you out in the future. Otherwise, I'll be here the week after. I'm going to try to come in every Tuesday again with an email or a video. But if you have any questions for me, I'm more than happy to answer it. This is the kind of thing I really like to do. This is, I love to make sure that people are able to pass the bar. You have a good idea of what your answer is. So no matter where you are in your law school career, please reach out to me if you have any questions. Michael Lofts. I'm speaking for him, but I know him and he's great. And he's also more than happy to help. So again, our contact information's up here. Again, you can put my name into YouTube. I'm more than happy to help. Otherwise, good luck on the MBE questions. Good luck in Jeopardy. I'll see you all next week.